Court of Appeals, Division 1 is now in session.
Please be seated. This is the time scheduled for oral argument in Arizona School Boards Association and Arizona Association of School Business Officials, the Arizona Corporation Commission, with Arizona Public Service Company being the intervener. Our case number 1, CACV 15-0001. Each side will have 20 minutes for oral argument, and that means that the appellant, as you know, you'll have to watch your own time if you want to reserve any time for rebuttal. As far as the appellee and intervener, you get to split the 20 minutes, not 20 minutes per party, but 20 minutes per side. You should be aware that we have read the briefs, looked at the record, and conferenced this case, so we're relatively familiar with the issues and the facts. As you probably know from the order we issued, asking you to address at least one question. So guide yourself accordingly. You should also be aware that we are recording these proceedings, at least audio and probably video. So when you approach the podium, please clearly state your name and who you're representing, so it's clear on the recording. With that, counsel for the appellant.
Morning, Your Honors. My name's Tim Hogan with Arizona Center for Law and the Public Interest, representing the appellants' school associations. I'm going to take your, I don't know if it's advice or admonishment to heart here, and base my comments today on the questions that were posed in the order granting oral argument. I think that'll be most helpful. We've had a full briefing and then a Supreme Court decision and then supplemental briefing that have sufficiently refined the issues, I think. And I will say in advance that I'm not sure the questions posed, but I'll point this out when I think they weren't the right question. But I will use that as a guide in talking about the issues here. So this, of course, has to do with a rate increase associated with the with APS's acquisition of Southern California Edison's interest in the Four Corners power plant. The Commission had left the previous rate case open in order for APS to apply for the rate increase once this transaction was consummated. That happened at the end of 2013. And then at the end of 2014, after hearings, the Commission granted a slightly over 2%, $57 million rate increase associated with the acquisition of the Four Corners plant. So, question number 1 that was posed in the order. Whether Arizona Public Service Company presented and the Arizona Corporation Commission considered, and here's where I'm going to have a slight difference, updated financial information for APS unrelated to the acquisition of Units 4 and 5 at Four Corners. So certainly, APS presented information that was required by the rate decision as part of submitting the later application for a rate increase associated with Four Corners. There were 6 different elements of financial documentation that were required to be supplied by the company in connection with its application. Updated schedules, income statements, consolidated balance sheets, a rate impact analysis. That's not necessarily financial information, but so there were a number of categories of documents that were to be filed, and APS filed those. So yes, APS presented updated financial information. Now, the question is what the commission did with that updated financial information.
Before you get to that, did those filings include changes in plant, accumulated depreciation, contributions in aid of construction, advances in aid of construction, and accumulated deferred income taxes?
If you look carefully, Your Honor, at the consolidated balance sheets submitted in connection with the application that were updated, I believe, through March of 2014, so 9 months later, the decision was made by the commission. But if you look carefully at that consolidated balance sheet, you'll see plant in service, accumulated depreciation, and I think there may be some schedules in there as well that reference advances in aid of construction, and perhaps even contributions in aid of construction.
That's the consolidated balance sheet?
I believe so, Your Honor.
Do you have a file number on that?
I do.
That's okay. You've conceded it, so you've conceded that APS presented it.
Correct.
Okay. So okay. I mean, I will tell you that I looked at those, and I had a hard time finding everything that you just discussed, but I'm sure it's there.
Well, I didn't discuss everything. There's also the reference in the RUCO case to accumulated deferred income taxes, and then there's an ellipsis in the RUCO case.
And so I want to ask about that. What does that mean? Does that mean that there's more that needs to be provided?
That's a good question, because certainly the explicit items referenced by the Supreme Court in the RUCO decision are not everything that goes into a determination of rate base.
Oh, sure.
I mean, those are a few elements of what, for example, working capital is an element of rate base. You don't see that referenced in the RUCO decision. And so, yeah, I think it's meant to capture kind of the rate base, some of the rate base elements, but certainly not all of them.
In terms of while we're discussing this, something that we have discussed, and we certainly like your help on, in paragraph 16 of RUCO, it notes that although commission will not recalculate anew every input into the fair value determination, the updated measurement is satisfied. Right. So I guess the question I have is, what's the difference between calculating anew and updating? It seems like if it's updated, it's kind of calculated anew.
Well, the way I interpret that, Your Honor, is that you take the previous rate base and that was determined in the overall rate decision from 2012, and you supplement and update. You use that as the starting point. Mm-hmm. You don't calculate everything anew, but you use that fair value as determined in that decision as the starting point, and then update and supplement with the required financial information to make a new determination of fair value. But you're not calculating it anew as if it had never been filed. You use what had been filed previously.
Does the commission have to, does the commission, I mean, what the court said was the commission will not recalculate anew every input into the fair value determination. But does it mean that the utility has to update everything? But the commission doesn't have to recalculate it?
Well, fortunately, we don't have to answer that question in this case, Your Honor, because the commission did nothing. The commission simply took, and this is a critically important point, and it goes to whether or not the commission has the question about considering. RUCO makes it plain that you don't have to just consider the financial information. When it comes to fair value, determining fair value, you have to find fair value. You have to update and supplement the fair value finding. It's not simply a matter of considering information that had been filed. That's the core requirement for rate making in Arizona, that the commission finds fair value, ascertains fair value to assist it in the discharge of its duties in setting rates. It did not do that here. All it did was take the Four Corners amount, and this is undisputed. I mean, the Four Corners amount, and add it to the amount that was previously determined as fair value in the previous APS rate case. That was $8.1 billion. That was the fair value rate base from 2012. The acquisition adjustment or amount associated with Four Corners was another $255 million. They added that to the amount, to the $8.1 billion, and got $8.3 billion.
Well, but isn't that taking advantage of what Rucco says, that you don't have to calculate it anew? If you have to, give different values to the components, aren't you calculating anew?
Well, let me refer you to a previous portion of the same paragraph that talks about anew, which I admit is a little confusing. But previously in that paragraph, that same paragraph 16, the court says AWC must submit up-to-date financial statements with each surcharge application, including an updated rate-based schedule, adjusted rate-based schedule in which the value of SIB projects, that's akin to the Four Corners, SIB projects is added to the underlying rate base. Using these financial statements, the Commission will also update the fair value rate base and other elements of the formula from the most recent rate case to recognize changes in plant accumulated depreciation. That couldn't refer to anything else because they've already talked about the SIB amounts. I mean, it is, otherwise you are sanctioning using a stale, old, not up to date fair value determination and simply allowing a plant to be added to it over time.
Then isn't what you're then advocating that basically an entire new rate hearing?
No, not at all, Your Honor.
So, I mean, if APS buys a piece of property, they said, listen, here's our rate base. Here's the fair value. And everybody agrees, for whatever reason, this is the fair value. And it says, next year we're going to buy something that's worth $1 million, added to the rate base. And they update that. A year later, they update that. And they say, okay, we make the purchase. $1 million is added to our rate base. The commission considers it, says, yep, $1 million is added. You're saying, what I'm hearing is that you're saying, no, something may have happened to the fair value of all their plant and of all their property, and therefore everything has to be updated anew. Everything dealing with the rate base has to be, or the fair value has to be re-updated, because otherwise it becomes stale.
It's not just that it becomes stale; it's unconstitutional.
Yeah.
And I'm going to reference the Skates case, which I think still is good law under the Rucco decision. There's finding fair value, and then there's considering the impact of a rate increase. You have to keep those separate, and the Supreme Court in Rucco made it very clear those are separate. The determination of what an appropriate rate of return is not related to the fair value determination. So yes, Your Honor, it's a certainty that the rate base has changed. It's an absolute, from day to day, the rate base changes. And so that's exactly right. And what Skates allows the Commission to do, and I think what Rucco allows the Commission to do as well, is take summary financial information and use it to update and supplement the previous finding. That's exactly what it allows it to do. Not to have a whole new rate hearing.
You're losing me.
Well, to take the information from the consolidated balance sheet that we talked about earlier and say, okay, a plant in service has changed. It's now this. Accumulated deferred income taxes have changed, and it's now this. So here is the new, we do that arithmetic exercise, and if the commission has any questions, of course, it can ask those questions.
That sounds like calculating a new, and I'm not going to get hung up on that phrase, but I thought the purpose of allowing this procedure was so that the commission doesn't have to go through an entire full rate case, which has all kinds of attendant costs, that if they had to do that, would discourage these kinds of acquisitions.
Exactly, Your Honor, and Skates permits that, and RUCO permits that, to take financial information that's submitted by the utility to avoid going through a protracted rate hearing.
Go back to my hypothetical. The commission approves the rate increase with the idea that APS or some other utility in a year is going to purchase something for a certain amount of money that will add value to their property. A year later, that purchase is made. APS submits the data on that related to that purchase, and the commission approves a new rate increase based on that that incremental, that discrete purchase. RUCO allows that. Am I right? What went wrong here? In your view, why doesn't this comply with RUCO?
Perhaps I agree. I don't think RUCO allows you to just add the incremental rate base attached to the single item. I don't think RUCO allows that. It requires the rate base to be updated and supplemented,
Right.
and to make a new finding, and so.
And it does that. I mean, the commission looks at the additional information and says, fine, the additional information is now your plant is worth $1 million more, and we're approving a rate increase based on that.
That does not, if you've updated and supplemented and found the fair value and allowed a rate increase, use that as the basis for setting rates, you're right, RUCO permits that. But that's a requirement of the Constitution that the fair value be updated and supplemented in order to allow the commission to do that. Distinguish that from the situation in Skates and what I think the legal standard would otherwise be, and why this can't just go on forever, which is the commission has to look at the impact of the rate increase on the overall rate of return for the company and make some determination about that. And Skates actually says. And so the question is whether you get into an abuse of discretion at that point, as in contrast to the constitutional requirement that fair value be found at the time of the inquiry based on current fair value of the utility. That's an absolute constitutional requirement. When the commission does that and then makes some assessment about whether or not the rate increase is going to affect the utility's rate of return, then you have an issue about, well, did the commission abuse its discretion in not looking at other items from the income statement? Have expenses gone up? Have they gone down? What about revenues? What about taxes? Those are all the other things that you might look at in determining the overall impact of the rate increase on the company's rate of return. And then that's an abuse of discretion issue.
But we're looking at fair value, right? If we're looking at the fair value rate, fair value.
Right.
So the fair value is increased. They make a determination fair value has been increased, and they set a new rate. That's permitted under RUCO, right?
I don't think it's permitted without updating and supplementing. For example, accumulated depreciation is reducing rate base at the same time, correct? I mean, that's why you have to look. That's why you have to look at that.
That was submitted in this case.
It was submitted, but it wasn't used to find fair value.
I know that. How do we know that it was
It's
not?
undisputed, Your Honor, that they took the $8.1 billion, the commission admits this, and simply added 4 corners to it.
Mm-hmm.
They didn't make any other adjustments to fair value. None.
So in Judge Kessler's hypo, it would be adding the $1 million, just adding $1 million to the previous fair value, and that would be the new calculation. I mean, without looking at any.
RUCO permits that to be done if you have updated and supplemented the previous fair value determination. But you cannot leave the previous fair value determination alone and simply add the new plant without taking into account accumulated all the other changes that have occurred to fair value.
Because otherwise, in RUCO, the Supreme Court would have just said as much. Why didn't they just?
I think they did say that.
No, well, if they wanted to only be the cost, the incremental cost, they would have just said that, and it would have been a 1-paragraph decision.
I think that's correct, Your Honor. Why even say anything further about it?
How do you update the components in the fair value determination and take them into consideration without recalculating them?
Well, there's some calculation involved. Obviously, you've got to add and subtract things. But it's not anew in the sense that it's like zero-based budgeting or something like that. We're not building it from the ground up. We have a fair value determination as of a moment in time from 2012. We take what's happened since 2012 to adjust that number. That's why it's not anew in the way that I think about it, at least. If it was anew, you would do an entirely new fair value determination for all the property. You'd figure out reconstructed costs, which is an element of fair value. You're not doing that here. That's why you're not completely redoing this. You're taking what was determined previously and adjusting it.
So if there's any component, and I assume all components change from day to day, then you're doing the math again. Well, before we talk about it, you're doing the math again.
You're making adjustments that take a calculation. Correct.
Let me see if we're out of time, but let me see if I can summarize what I've heard and tell me if I'm wrong. Your contention is that you can start with the original assessment, the fair value determination from 2012. APS can come in and say, okay, we've now added the value of 4 and 5. But and that APS submitted additional updated data. But that the commission then has to recalculate the effect of that updated information to the entire property, or only to the updated information as affected by 4 and 5?
To the entire fair value rate base.
Right. So in other words, if something else changes from the first determination of rate base, of fair value, to the new acquisition, the interim, regardless of, let's say, the value of 4 and 5 is X, APS has to submit new data on all these other factors unrelated to 4 and 5, related and unrelated to 4 and 5, so the rate base can be redetermined.
They have to submit at least summary data in connection with that.
Right,
That's
but
what
it might not pertain to 4 and 5.
That's
it
correct.
Pertain to everything.
That's correct, and it explicitly would not pertain to 4 and 5.
Okay.
Otherwise, you haven't captured the other changes that have affected a change in the fair value of the property.
And that's the crux of your argument.
Pardon?
That's the crux of your argument, is that the Corporation Commission has to update the other factors, even if they're unrelated to the specific acquisition.
Absolutely. This is an overall general rate increase. It has to be based on the fair value of the company's property. And that means all the fair value, and it means the current fair value. And Rucco made it clear it has to be the current fair value. It said so at least twice in the course of the decision.
Okay.
Thank you, Your Honor.
Thank
Any
you.
other questions?
Thank you.
May it please the court. Maureen Scott on behalf of the Arizona Corporation Commission. I will be splitting my time with Melissa Kruger, who is representing intervener APS in this case, who will be taking 8 minutes, time permitting. I want to begin right away by answering the court's questions from your July 19th, 2017 order. And I want to state that if at any point you would like cites to the record, please let me know. I would also note that APS brief has an appendix which contain most of these documents.
Most, but not all.
Well, can you answer for us whether you agree with the last statement of counsel about what has to be done?
Judge Howe, the Commission does not agree with that interpretation of RUCO 2. If you look at the language from the Supreme Court's order and you look at the reference that they're not citing any fair value determination. They're citing back to the earnings test. And in the earnings test is where you look at.
Are you in paragraph 16?
You're in paragraph 16, and you're referring to the Corporation Commission decision 73938, and then there's other numbers. Is that what you're referring to?
Yes, I'm referring to the language that Mr. Hogan has cited, and the specific cite back to the record of the Commission's decision.
And how do we know that relates to earnings? Does that link the record reference?
It relates to earnings because in the SIB decision, the Commission adopted an earnings test so that when they considered the updated information and the revenue generated by the SIB, it could not exceed its authorized rate of return. And that reference is to that earnings test. It has no application to the fair value determination that was used.
But it's part of the same sentence that says the Commission will also update the fair value rate base and other elements of the formula from the most recent rate case to recognize. It doesn't say that's all you're going to look at. What does that mean? The Commission will also update the fair value rate base. Did the Commission do that here?
The Commission asked for updated financial statements, and the updated financial statements were provided by APS.
I understand they're considered, but did the Commission do the update of the fair value?
The Commission updated all of that information for purposes of the earnings test and considered it. For purposes of the fair value determination, the Commission did not update that determination with the plant unrelated to Units 4 and 5. The Commission updated that information with respect to Units 4 and 5.
In other words, it was just a simple math exercise. It was $8.1 billion plus $255 million equals $8.355 billion.
Well, the
right?
Commission would have had to have updated the accounts for the new Four Corners plant. So it's not, I don't know if it's quite as simple, but they would have updated, those financials would have contained updated information for Units 4 and 5 as well. And that would be included in the fair value determination. Oh, I'm sorry.
Okay. I don't mean to interrupt you, but I asked Mr. Hogan the crux of his argument. And the crux of his argument, as I understood it, was that the APS has to submit and the commission has to update these other factors, even if they're unrelated to the specific acquisition involved. And if I understand what you're saying is, you only updated and considered these other factors as they related to the acquisition of 4 and 5.
Except for purposes of the earnings test, Your Honor. And if you look at that as part of this whole fair value consideration, that all of that plant, all of the changes to APS's financials were considered for purposes of determining whether they exceeded their authorized rate of return.
Even if it was unrelated to 4 and 5.
Yes, that's correct.
How do we know that occurred?
We know that occurred because of the financial statements submitted by APS. We know that occurred because all of that information, including a lot of confidential information regarding the earnings of the company, and confidential exhibits that were filed were in the record. All of this information, and in addition, staff's witness, Dennis Karbasik, did an examination of all of this, and that's in the transcript of the record.
Okay, Mr. Hogan said it was undisputed that the commission did not update other matters unrelated to 4 and 5.
For purposes of the earnings test, that's not correct. We looked at our witness, expert witness, looked at all of that information.
Where's that in the record? Which volume of the 60 so volumes is it in?
Your Honor, yes. At page 36 of our answering brief,
Yes.
you will see all of those sites listed. Certified record B20 at 619 to 20.
And that's the testimony?
Yes, that is his testimony in the evidentiary proceeding.
Okay.
The same at the transcript, same site at 624. And then there's also a reference to the transcript again at 643.
Okay. So if I understand what you're saying is, you looked at the value of the acquisition of 4 and 5, you, meaning the commission, considered that, and considered other matters unrelated to 4 and 5 for purposes of earnings. Was that consideration affect the rate base and the fair value determination?
That goes more to the other side of the equation, the rate of return and the Commission's overall rate-making authority, Article 15, Section 3. I would like to put this whole discussion in a little bit of context. The SIB did use the fair value finding from the company's last rate case and the fair value of the SIB plant only to determine fair value, and because it essentially defines the upper limit of what they could request in this case. These are narrow rate-making mechanisms designed to put plant into service between rate cases. It's not designed to be a new rate case where you update all the plant and all of these other different elements. That would defeat the purpose of it. So it's
and that would be a new calculation where
yes.
the Supreme Court says you don't have to do.
Yes, exactly. So if they wanted to request above that, they would have to come in for a new rate case.
Above?
If they wanted to request above the fair value from the initial case and just the Four Corners fair value added to it for units 4 and 5, if they wanted something above that, they would have to essentially come in for a new rate case.
In my limited understanding of this, what I hear you're saying is, yes, we considered all these other factors as unrelated to 4 and 5, but they went to earnings, not fair value.
Yes, we upped the, and that's the same in the SIB case. You use the determination of fair value from the initial rate case, and then you added to that the value of the SIB plant for that year.
But not all these other factors.
No.
Then why did the court say that? Why did the court say, I guess we get back, I mean, it's sort of circular, but I guess we're getting back to your saying, well, the court said the commission will also do the fair value rate base and other elements of the formula in paragraph 16, and you're referring us back to the Arizona Corporation Commission decision 73938 at 51, because that's dealing with earnings. But how does that, if that's dealing with earnings, why did the court talk about it in the context of the fair value rate determination?
Because I think it's acknowledgement by the court that this updated information is used in a portion of this rate-making mechanism. And it's used in the most important part of it, really. With respect to the fair value, if this is going to remain a narrow rate-making mechanism, you don't want to update all this other plant. Then you're going to broaden it, and it is going to become a rate case.
Well, counsel, could the court have been referring to, obviously was referring to the broad formula, which includes the fair value, but also other elements, the earnings, correct?
I think that could be, that's the way I would interpret it. They were talking about the rate-making mechanism, and they wanted to acknowledge that this full, complete update was taken into consideration in part of this mechanism.
So it was taken into consideration in making the formula work, but all of those other elements were used in recalculating the fair value. Is that correct?
Other than units 4 and 5 and the updates related to those, because otherwise you'd no longer have a narrow rate-making mechanism.
Thank you.
Mr. Hogan also stated that because of his interpretation of the RUCO 2 decision, that skates now becomes an issue. And the commission, of course, does not agree with that.
Okay.
Skates did not even involve a rate case. These decisions are coming out of rate cases. There have been evidence. With respect to this plant, I can tell you that this is probably the most scrutinized plant that's ever come before the commission. It's been scrutinized over the course of 5 years. It's had 3 proceedings. All of those proceedings were evidentiary proceedings. Any party could have come forward and offered evidence on any of this. So it has been a heavily scrutinized transaction.
So let me make sure I'm on the same page, at least that I understand what your argument, not that I necessarily agree with it, but that I understand. You're saying that what RUCO is really saying is, yes, you update all this information, but the commission only has to consider it as it relates to the new acquisition.
I'm saying,
I mean, the value of the new acquisition, I mean, the old rate, the old fair value is been determined. Now there's a discrete interim acquisition. And so that the commission has to look at what's the value of that for purposes of fair value determination, and will include, or at least consider, the updated elements of the formula, accumulated depreciation, contributions to native construction, advances in native construction, et cetera, all of those as it relates to the new acquisition. not
Yes.
going back and as it relates to all the other property that the utility owns.
Yes.
Is that a fair summary?
Yes, it is. Otherwise, you're changing the whole nature of this rate-making mechanism.
But you're determining the new rate with the updated information, right?
Yes, that is taken into account, again, yes, in determining the rate, to make sure the company does not exceed its authorized rate of return. The other point I'd like to make to that briefly is that with respect to the rate of return, authorized rate of return, there was a discussion in the Supreme Court about, well, what if the circumstances justify a reduction to it? The commission had before it all the information. If they looked at the information and determined that the authorized rate of return was no longer appropriate, the commission could always and would have adjusted that rate of return determination to what was constitutional. Another point I would like to make is that Mr. Hogan takes the position that the court in RUCO 2 somehow repudiated Arizona Community Action, which was a case that also utilized a step increase and determined fair value in the same manner we did here and that the SIB did. The court...
Of course, there's no reason, is there a reason for why we would have to weigh in on that?
Pardon?
Is there a reason why we would have to weigh in on that in this case?
I would just, probably not. No, there isn't.
If we can avoid it?
Okay. Your Honor, I think at this point I will turn it over to Ms. Krieger. I think I've gone beyond my limit.
It is a common problem when you split time that the person who goes second often doesn't get the entire time they expected.
May it please the Court, Melissa Kruger, on behalf of Intervenor APS, I'd like to add just a little context briefly. This is a rate case in two parts. That is what a step increase is designed to do. And RUCO 2 sets out very clearly that we don't recalculate the entire fair value rate base from phase one. We've taken a while to kind of get to that, but I think we've crystallized on you take the fair value rate base that was found in that full rate case and you update it and supplement it with the what happened, the piece you want to add in. And in this case, it was that additional share of the Four Corners plant. Now, all of that fulsome information that the company is required to provide, the Commission has all that. It looked at it here, and it needed that to make sure that this additional increase it was going to impose, the 2%, was just and reasonable in the public interest. And so it is a fair value is a piece of the puzzle, and what the Commission did here is identical to what happened in RUCO 2 and meets the constitutional requirements. Now, the practical effect of what the school associations have argued is really that nothing short of a full Rule 103 rate case is sufficient to set rates. And as RUCO 2 would instruct us, the Constitution does not require a full rate case in order to set rates, and I contend that to do so would be bad public policy. It would require an ongoing series of continual rate cases, which courts have recognized as costly, burdensome, time-consuming, both for the Commission, the utilities, as well as the public and private entities like appellants that participate in these cases. It would also make for a less certain regulatory environment in Arizona and likely increased rates for customers. And I'll cite as an example, in APS's last two rate cases, the parties negotiated what's referred to as a stay-out or a moratorium that says you're not going to file a full rate case for X period of years. The step increase mechanism in this case allows utilities to agree to such stay-outs. The Constitution allows it, and the Commission needs these types of regulatory regulatory mechanisms like a step increase. It gives the Commission the flexibility to address changing regulatory environments as well as challenging business and operational issues. in RUCO 2, that systems benefit improvement charge, helped solve a significant problem regarding the replacement of aging infrastructure. In this case, the step increase allowed APS to purchase Southern California Edison's share of the Four Corners power plant and avoid premature closure of that plant. Absent a step increase, these types of actions may not be necessary or may not be allowed. So in conclusion, the Commission considered and reviewed fulsome financial information here in connection with its decision on the rate rider. The record here demonstrates that the Commission met its constitutional duties under Article 15, Section 14, when it found fair value by taking the fair value from Phase 1 of the rate case and adding the fair value that it found in Phase 2. The record also demonstrates that the Commission took steps to ensure that the rates would be just and reasonable under Article 15, Section 3. And to that end, I would refer the Court to some of the things in our appendix that were Commission witness Dennis Kabarchek's testimony, where he testified he looked at the income statement, the capital structure, and other summary financial information.
All of that related to 4 and 5.
No, that information is company-wide information. That's not about the fair value rate base, Your Honor. That those are about, does this discrete increase, does it cause the company to over-earn, exceed its authorized rate of return? Is there any adjustments needed? I mean, think about fair value as it's something that has to be done, but it is. And there's lots of formulas and lots of math, but it is not so formulaic that you take fair value and it equals a rate of 0.2 cents. It is something the Commission has to consider in its discretion as it is setting this whole complex rate structure.
If I understand your point, and I want to make sure I understand it, it is that, yes, the information in determining fair value, the Corporation Commission can just look at all this updated data as it relates to 4 and 5. But then in determining whether the rate of return is fair, it could and did look at all these income statements and earning statements as it related to the entire APS, to all of APS's property.
I think that's a fair summation, Your Honor.
So there are other components to the formula besides fair value then?
Certainly, rate making is a very complex exercise requiring expert and accounting testimony. Yes, Your Honor.
Good. Thank you.
Thank you.
Thank you to all the attorneys for their arguments. We will take this matter under consideration and issue a written decision in due course. With that, we are stand adjourned.